Secretaries of India. I have done my executive masters in international business from the Indian Institute of Foreign Trade and of course LLB. I have worked at various places which included 1993 to 1991. I was with a state government undertaking, Delhi Tourism Development Corporation. Out of this 8 years that I spent there, first 4 years I was the CFO, that is finance manager, and next half, about three and a half years, I was CFO cum company secretary. I left Delhi Tourism Development Corporation in 91 to join India International Center as controller of accounts. I stayed there for 3 years and left that in 94 to join FICCI. Stayed there for 2 years and left that in 96 to join International Labour Organization and continued to stay there till around 2013, nearly 17 and a half years. And since then, I am practicing law. Am I audible? Hello?
Yes, sir, you're audible.
Okay, yes, sir, good. With this with this very brief introduction, I am very pleased to be here with you this forenoon. We are going to be together for about 2.5 hours to speak on two important topics of your interest. That is the Transfer of Properties Act and the Indian Stamp Act. I have a choice with you that whichever you are, though even though I have set the PPT on the Transfer of Properties Act, thinking that it is relatively longer, but I also have a choice in case you feel like I can switch over to the Stamp Act first. So that's no issue. In case any of you have reservation, please let me know. And I also thank the Institute of Cost Accountants of India, ICAMI registered valuer organization, for giving me an opportunity, and to the technology that we can speak to interact with each other from such a far off places. The rule of the game would be, while I try to be little slow and step by step, but still there can be a doubt in what I say and what it reaches you, or sometime I may not be clear on, or maybe something may not be understandable to you. There are two alternatives. One is you can note down the topic, and in between, whenever we have covered about, say, 40-50% of the syllabus, I will try to halt, close the PPT, and will try to have direct interaction with you. But in case you find that something is urgent and interesting, don't worry, just feel free to unmute yourself, say whatever clarification you have on the subject. Is it okay? With this little explanation, shall I start with the Transfer of Property Act itself?
Yes, sir, you may start.
Okay. Please don't mind. In between, I will keep on asking. Number one, to assure myself that I am audible with you. Second is to set my own path as to what do you want. So be frequent, be active in trying to mute and unmute yourself at a relatively short kind of a notice. I think that will make it interesting. Otherwise, it can also happen if you don't recheck each other's availability, there can be a possibility that I might end up saying something continuously for 5 minutes and even a single word doesn't reach you. So that can be another difficulty. Please feel free, और जितना थोड़ा अच्छा interaction बनाए रखेंगे, मेरे को भी थोड़ा interesting लगेगा. Okay. So when we think of the Transfer of Property Act, what are the things you think will come to our notice? Definitely, we would like to know as to what is property. We will take a definition of the property. Then we would also like to know what are the possible kinds of property which is subject to transfer under the Transfer of Property Act. Movable property, immovable property, what will happen to tangible and intangible property, what are the characteristics of these kinds of a property, and whether the Transfer of Property Act provides for any specific mechanism, formality, or certain procedures to be followed for effective transfer of property. And in the transfer of properties, we will also know what is transfer, what is not transfer, and What can everything be transferred? If I have something very precious, can I transfer everything, whatever is available with me? Are there any restriction as to transfer? Are there certain things which are not transferable at all, either under the Transfer of Property Act or under any other law which to which we might be subject? Then if once I know as to what is property, what is transfer, what can be transferred, what cannot be transferred, then what is the means effective, what is the methodology involved in transfer of property? Can I transfer property by giving just a simple delivery, or do I have to enter into an agreement in writing? If so, whether I also have to register that agreement? Those are the kind of things which will be required to be studied, and that will become the part of the study of the today's course. I will try to make it as interesting as possible, but real interest will lie in your equal amount of participation wherever you feel like. So friend, this will, as I have said, this is what I propose to take up with you. Read it, and if you want, if you feel free, I am not going to read this, but will just halt for a fraction of a minute, so you are able to read it. You can also take a, say, a photograph or something in case you want to ensure that all these topics which I promised in the beginning, they have been fully taken care of. And wherever you find that I am very fast, feel free to call me. I don't mind going back and forth in the PPT. I can also go back in the PPT wherever you feel like. And in case you feel that I am too slow on a particular stage, ask me to go a little faster, because we are also concerned with covering both the topics almost equally. Then we will also take up certain specific types of transfers such as sale, mortgage, lease, license. And when we take up mortgage, sale, license, lease, exchange, and there will be right of the parties, that in case of a sale there will be right and liabilities of the seller and the buyer. In case it is a mortgage, there will be rights and liabilities of the mortgager and the mortgagee. And in case there is a lease, then we will take up rights and liabilities of the leaser and the leasee. And of course, at every stage of our presentation, we will continue to interact with each other in trying to pose the question and answer this. So friends, this Transfer of Property Act is quite old, right from the early British days of 1882. And this act is governed, the transfer of property in India till today is governed by the Transfer of Property Act 1882. Prior to this, there was practically no law as to transfer of immovable property. And whenever there is no law, even today, there are certain issues where there is no law. The courts apply the English law as to the rule of justice, equity, and good conscience. Justice, equity, and good conscience means being fair to the parties who are present before you. You know, the court has got the job of interpreting the law, and on the process of the interpretation, they also give judgment in favor of one party or the other, keeping in view the provisions of a specific law. And wherever they find that law is not clear or a particular situation does not provide any law, courts provide the principle of justice, equity, and good conscience. That means they try to take both the parties which go in litigation before the court, and they try to apply the principle of being fair in a given set of circumstances. So this is what principle was applied even relating to the transfer of immovable property prior to 1882. So the object of the Transfer of Property Act is to amend the law relating to transfer of property inter vivos. Mark the word inter vivos. Inter vivos means transfer by act of the parties. And under this act, under the Transfer of Property Act, we will be more concerned with only those kind of transfers which are effected by the act of the parties. But you will also ask me, is there any other way also of transferring property? Yes, friends, there is another way of transferring the property also. Say, for example, I have a property and at some point of time I have not performed my legal obligations to some statutory authority, say income tax department or GST department, and some liability has accumulated against me. What those statutory departments will do? First of all, they will write me a letter or a show cause notice or a note warning or something. They will say, call upon me to deposit my dues, and in case I fail to deposit, they will they may attach my property. After attachment, after follow certain procedure, they may confiscate that property, and after confiscation, they may also sell it, and that sale will not be with my consent, but that will not be inter vivos, but that will be by operation of law. So friends, there are two ways in which the transfer can be effected. One is under the Transfer of Properties Act, which is inter vivos transfer, which is under the with the act of both the parties. That is, in the case of a sale, it could be seller and the buyer. In case of a mortgage, it could be mortgager and the mortgagee. And in case of lease, it could be leaser and the leasee. So let's try to know as to what is the property. The term property signifies the subject matter over which the right of ownership, which means property is something over which I exercise the right of ownership. Is it the only property? Is it necessary that I should have ownership right on any kind of property or every kind of property? Is the ownership only way of owning the property? No, friend. I could also be owning a leasehold property, or I could be owning a property which is a mortgage property with me. I could be exercising my power as a mortgagee. So the term property signifies the subject matter of which the right of ownership, that is the first one, or any lesser right carved out of ownership, which means I'm a leasee of a property. I don't have a full ownership right, but still I have some right. Like that, whenever I am a mortgagee of a property, I'm not a owner of the property, but as a mortgagee, I can exercise certain rights which have been given to me under the contract of either lease as a leasee, and as a mortgagee under the mortgage agreement, certain rights may be given to me. So the property signifies any subject matter over which either the right of ownership or the right of a mortgagee or right of a leasee where I can exercise. And this property may be either movable or immovable. Transfer of Properties Act does not define the term movable property. It is to be defined with the help of some other statute. So let us, and this is the principle of interpretation of law, that whenever a particular item or a term is defined in a particular enactment, then that definition shall apply in relation to that term. And wherever a particular term is not defined that enactment, then we'll try to find out whether any similar enactment defines that term. Then we try to borrow that interpretation from that enactment. And since the Transfer of Property Act does not define the term movable property, let us see where it is defined. Movable property has been defined in General Clauses Act of 1897. In fact, wherever in whatever law any term is not defined, then the General Clauses Act tries to answer this by giving certain interpretation or certain clarification or certain definitions of how those things shall be defined. So as per General Clauses Act, the movable property means property of every description except immovable property. So it's going to be a little tricky before we get to know as to what is the distinction between movable and immovable property. Here it gives as vague a definition as even if we did not have this definition, so we definitely know what is movable will not be immovable, and what is immovable will not be movable. So it says movable property means every property of every description. Of course, that will be movable, would except immovable. Then what is the immovable property? The Registration Act 1908 defines movable property to include property of every description excluding immovable property. Up to this, friends, up to this, The definition given under the General Clauses Act and the Registration Act is exactly the same. It doesn't make any difference. It doesn't help us in going over to the next enactment, but then it gives a little more, which give us little more hope. It says, but including standing timber, growing crop, and grass. So, friends, even though these things, standing timber, growing crop, and grass, look like attached to and farming part of the earth, but normally, whenever we enter into a contract for transfer or sale of these things, timber, growing grass, and grass, the normal understanding is that the buyer or the transferee will sever these from the earth and take them away. So this, in any case, at least one thing we know that any point of time, standing timber, growing crop, and grass will be a movable property. Movable property, friends, is very similar to goods. There are two laws which govern the transfer of property. Largely, you must have been aware of the Sale of Goods Act of 1930, which deals with sale of goods. And there it gives the definition of sale. Also, it defines goods. Let us try to understand whether by understanding the definition of goods, it helps us in any way trying to understand the definition of or some try to help us in making a distinction between movable and immovable property. Goods is defined in section 2(7) of the Sale of Goods Act as it says every kind of a movable property other than actionable claim and money. So at least some clarification is there that goods will mean every kind of a movable property other than actionable claim and money. A little later, we will understand actionable claim and money means whatever is the legal tender by virtue of which we can transfer certain value from one person to another. Legal tender is money. That means if I take out from my pocket a 20 rupees note or a 10 rupee note, that is money. But if I take out from my pocket some coin which was accepted as a legal tender during Mughal era or during the period of Chandragupta Maurya, but it is not accepted today, that will not be money. And movable goods, friends, under the Sale of Goods Act include stock, shares, again growing crops, grass, and things attached to and farming part of land which are agreed to be severed before sale under the contract of sale. So again, we get to know that growing crop, timber, and grass are going to be part of the movable property only. And actionable claim, though I propose to define it a little later, section 3, this is also part of our syllabus today. Section 3 of the Transfer of Property Act defines actionable claim to be claim to any debt, but other than these three things. Actionable claim means claim to any debt other than a debt secured by mortgage of immovable property or hypothecation or pledge of movable property or to any beneficial interest in the movable property not in possession of the claimant. That means, in simple words, actionable claim means a claim to any unsecured debt. Examples of the actionable claim could be that you have a provident fund deposits with the provident fund authorities. You have a right to recover that amount, right to sue, or you have a right to, you can claim that amount as a debt recoverable from the provident fund authority, but that debt is not secured by any mortgage of provident fund authorities property with you. You also don't hold anything, a hypothecation or a pledge of any movable property, and that is also not any beneficial interest in movable property not in possession. Like that, if you have some gratuity receivable or if you have made some deposit under the some scheme, let's say LIC recoverable is there, so all these will be actionable claims. So let's come to now try to take define immovable property. Immovable property is that which cannot be moved from one place to another. It is generally connected to the ground or a land on which it is fixed. According to section 326 of the General Clauses Act, immovable property shall include land, benefit arising out of land, and things attached to earth are permanently fastened to anything which is attached to earth. That means land is an immovable property. Anything which is constructed over it, walls, and over the wall there is a roof and the ceiling. So all this building is a immovable property. Within the building, something is fastened to anything attached to the earth. Walls are attached to the earth. On the wall, there are windows, there are doors, there could be some essential fitting. So all these are included within the term immovable property. So let's come to now the Transfer of Property Act itself. It says, according to Section 3 of the Transfer of Property Act, immovable property does not include standing timber, growing crop, and earth. So normally we will follow this definition of the Section 326 of the General Clauses Act for our understanding of the immovable property, and then we will also know standing crop, standing timber, growing crop, and grass, even though apparently they look like affixed to, are fastened to, are rooted in the earth, but they will continue to be movable property. They will not be in immovable properties. And immovable property include land. This I have already taken up you. Immovable property does not include standing timber, growing crop, etc. And last thing, three things are regarded to be severable and not included in the terms of immovable property. Courts have from time to time defined right to collect rent of a immovable property. You have a tenant, and every month you are supposed to, or you are entitled to receive rent, whether it's a movable property or immovable property. Normally, since the rent is receivable on immovable property, court has recognized this also to be immovable property. But say same tenant has been defaulting in making payment of rent. You filed a petition with the court. Court has passed a decree. An order is with you for recovery of money. Now this recovery get detached from the property, and in case you have a decree for getting execution in your favor, then it becomes a movable property. The right to passage or way, say you have a piece of land, say agricultural land, in order to avail of, in order to utilize the land, you also have a right to passage on somebody's land. So you can use a road going to your piece of land. There could be some passage, there could be approach road. So all that is also immovable property. Right to collect dues from fair on a piece of land. You might have a piece of land, say like you are owner of the Pragati Maidan, and you can rent it out that Pragati Maidan, and then you have a right to collect dues from fair on your piece of land. So it's a immovable property. Interest of a leasee or a mortgagee of a immovable property is also immovable property. Like that, a right of ferry. Ferry means to do little bit of shipping or a boating on the land, or fishing, or and any such utilization you can make. So that's also immovable property. Right to receive future rent on your land, then reversionary right in a property leased or a factory, all these are immovable properties. Reversionary or reversion or reversionary rights means a bundle of rights remaining with the leaser or a mortgager after the execution of the lease or a mortgage of certain immovable property. So that's also immovable. Reversionary right or reversion right are immovable property. Some of these have been held to be movable property. That means government promissory note. Sorry. Anji. Hello. Hello. Am I audible?
Yes, sir, we can hear you now.
Sir, since when did you lose track of the PPT? Did you see this PPT? I'm just going back one by one.
Yes, sir.
Yes, sir. Visionary.
You have seen this PPT?
Yes.
Yeah, slide 22 finished or slide 23 now?
Slide 23 you have seen.
Yes, sir.
Okay, good. But fortunately, you have not
Earlier, why
lost
is not
much.
coming?
What is not coming?
It was not.
Actually, from the beginning, it was not seen. Now, 24.
Okay,
Slide.
okay.
It was not coming on full screen. Now it's coming on full screen.
Okay. You are able to see me also?
Yes, yes.
Friends, in the beginning, I told you
Yes,
that whenever there is a problem, we should not keep quiet. We should raise our voice. Ideally, to me, when I am able to hear. But in case I go out of signal or I am not accessible, then you have a mobile number of our organizer. I am also connected with the organizers. That means that we have a Nitin and we have a Sandeep. Both are accessible. We are all educated people, and whenever you find there is a problem, please raise your voice. Is it okay? Am I
Yes, sir.
audible?
Yes, sir, we can hear you. Please
Sure.
do that.
Okay. Okay. Fortunately, maybe it is a blessing in disguise. Let me interact with you a little bit and have a feedback. The way I am proceeding, is it understandable to you?
Yes, sir.
Yes, sir.
Do you have any issue where you felt like asking me but were hesitating, just as PPT went out of visibility and you did not ask? So in case you have to ask anything, please feel let's be friendly, even though we are not able to clearly see each other, but we are all professional friends. Let's try to be little more friendly.
So you
Sure.
will also be sharing the presentation at the end of the session, right?
There is a presentation.
You will be sharing it at the end after the
Not necessary, but in case you find some interesting point you want to make in between, there is no point in waiting till then, because more you allow me to just go on speaking, more dreary and dry do I feel कि मेरे को खुद बल्कि पता ही नहीं चला कि when did I go out of signals and I went on speaking. तो कहीं आपको ये लगता है, try to keep it somewhat I'm not saying कि we just go on chatting without covering our syllabus, but at the same time we should keep somewhat interactive. Is it okay?
Yes, sir. Sure.
Yes, sir.
Okay. I was telling you reversion and reversionary rights. Whenever I mortgage a immovable property, then obviously the terms of mortgage is that a mortgage is always revertible. So whenever the borrower repays money to the lender, the property which he has mortgaged will revert back to the borrower or mortgager. Like that, when I lease my property, certain right in the property gets transferred to leasee. He can make use of that property. Physical benefit उसका ले सकते. जब किराए पे मकान देते हैं, the tenant get a right to live in that building, but that at the same time, the leaser also continue to have certain rights in relation to that building. So both right of the leaser and that of the mortgager are classified to be, or they have been decided by the courts to be immovable property. Okay, is it clear?
Yes.
Yes, sir.
Okay, great. Yeah, that's glad. So I was at this stage. I think we did not lose much. Government promissory notes are movable property. Royalty receivable is movable property. Right to recover maintenance allowance. So there might be some family arrangement under which I am an old man. I might have been given right to maintenance, and property might have been taken over by the other members of the HUF. So I have a right to maintenance. So monthly they have fixed some bhatta for me. So that's a movable property. Copyright, decree for areas of rent. I told you a little while before that it's a movable property. Machinery which is not permanently attached to the earth, which as per the terms of the agreement can be severed from the earth, removed or unplugged from the earth, and or that it can be taken away from the earth and taken away by the buyer, like that standing timber, growing crop, grass, etc. are all movable properties. So friends, so far we have spent quite some time to understand as to what is a property, what is movable property, and what is immovable property. Along with illustrations and decided cases, I have tried to take up with you a first part of my presentation, that as to what is a property. And since we are going to deal with the transfer of property, it's important to understand as to what is transfer. Section 5 of the Transfer of Properties Act defines transfer. And according to this, transfer of property means an act by which a living person conveys or delivers or carry or communicate or cede or give it to या किसी को देता है property in the present or in future to one or more other living persons or to himself and one or more other living persons. This is the definition of transfer. I think it must be somewhat Greek, you might not have understood. Let me try to dissect this information, this particular definition, or break this definition and try to understand in part. Transfer means an act by which a living person, that means a person should be human beings, and not only human being, but living person includes a company, an LLP, an association of persons, or body of individuals. A transfer of property is an act by which a living person conveys, means gives, delivers, or carries property in the present or in future. So property definition we already know. Property is something over which a right of ownership or some other right could be exercised. Transfer could be property which is present or in future. So I have a power to, just as in the case of sale of goods, under the Sale of Goods Act, I can sell goods or I can enter into an agreement to sell. Like that, in the case of a transfer may take place in the present, right at the time of giving or taking, or in future. Sometime I may enter into an agreement for sale of an immovable property, in which case agreement to sell is today, but the sale would take place at some future point of time to one or more other living persons. So when I am selling, I can sell it to another person, or I can sell it to a group of other persons. So I am a seller, I am a sole seller, but I can sell it to, say, a joint buyers. So in that case also it is possible. Or to himself and one or more other living person. Means I have a fully owned property. I am the sole owner of a property, and I transfer it in such a manner that a part of the property gets owned by another person. That means instead of fully owned property, I convert into jointly owned property. So in joint ownership, somebody else also joins in that property. And to transfer property is to perform such an act. Now I will read it, the whole definition together. Transfer of property means an act by which a living person, again, living person need not necessarily be human beings. They also include body corporates, association of persons, and body of individuals. In a present or in future, so transfer may take place either in present or in future. It uses the word transfer, but in order to make somewhat clear, I have used at times sale. But transfer is, there is a difference between a transfer of property and a sale of a property. Sale of a property is a subset of the transfer of property. In the sale, I transfer my ownership right to somebody else. But in the case of a transfer, I need not necessarily be transferring the complete ownership right to another person. I might be transferring some interest in the property, and the other person gets an interest either as a leasee or as a mortgagee or in some or licensee or in some other manner. Or and the transfer may be from one to many or one to one, or it could be one means myself to myself and my brother, or myself and my brother. So all these will be transfer of property. And to transfer property means to perform such an act. I already told you the living person.
Can you please elaborate to himself part once?
Yeah. To himself and to one or more other person. I am a sole owner of the property and I transfer it to myself and to my brother. So till today, I was a sole owner of the property. From tomorrow onward, after the transfer take place, then me and my brother also acquire some interest in the property. So we become the joint owner of the property.
Got it, sir.
अपनी property को में दूसरे किसी को हिस्सा दे देना will be to himself and to one or more other person. So there could be a situation where I vest my fully owned property to a partnership, or fully owned property to my HUF, or fully owned property which is in my name, to say I am old enough, so I know that someday I am very close to completing my life and dying. So what I do is, I don't want to fully transfer the property to my successor, fearing that they may take away the entire property and I may be left undone during my old age. What I do is, it is like you have your own bank account, you convert it into your account in joint ownership with your wife. So it is like this. So when you convert into solely owned property to a joint owned property, so that's covered in this line. Am I clear?
Yes, sir. Thank you so much.
Are you really clear about this? कई बार ऐसे होता है ना, you have a.
I am very much clear now.
Thank you very much.
Thank you, sir.
And living person includes a company, association of person, body of individual, whether incorporated or not. I don't know why they have used the word living person. These days, we mostly use the word person, and person includes a body corporate. But at that time, 19th century, I do not know what must be in their mind. They use the word living persons. Maybe the company form of management was not very popular at that time, but they still said that it includes association of person and body of individual. LLP were just not there at that time. They could not use it, so that you have to keep certain margins. So I told you, friends, the transfer of property may be by operation of law or by transfer inter vivos. Let us see when the property get transferred by law and when is the property transferred by the act of the party. Property may get transferred by law through sale in execution, forfeiture, insolvency, interstate succession. In all these four kinds of transfer, I as a owner of the property, or I as a mortgagee of a property, or a leasee of a property, do not do anything. Say sale in execution. For example, I default in meeting my statutory liabilities. The regulatory department, whether income tax or GST or enforcement director, they attach my property and get it sold in after obtaining the order of the court, and in the exercise or in the giving effect to the order of the court, my property is got sold. The ownership of the property passes from me to somebody else, even without any activity, without any execution on my part. So that is by operation of law. Like that in the case of forfeiture. So let me just explain a little more about the sale in execution. Sale of property under the authority of a court, where court can issue a writ of execution in order to satisfy an unpaid obligation. They may be, I had taken loan from the bank, I was not able to pay the EMI. The bank approached the appropriate court in seeking direction in getting attachment of my property, and court issue an order, writ of execution, in order to satisfy the unpaid obligation. Then and such a sale is a forced sale or a judicial sale without any inter vivos part from my part. Without any initiative from on my part, my property get transferred, ownership get transferred to somebody else, and I lose the right of ownership. That's also one kind of a transfer which take place through the operation of law, not through the act of the parties. Like that forfeiture, the loss, giving up or surrender of something, some property as a penalty for wrongdoing, such as forfeiture by bank of a property of a borrower for default in repayment of loan. So, particularly if I give a very crude example, I I was going on a car. Suddenly, I fell short of petrol. I looked around the pocket, did not have any money, but I direly needed some petrol on the way. So I pledged my watch over there, asked the petrol bunk to give me at least 3, 4, 5 liters of petrol and keep this watch. And I will come 2 days later to get it redeemed and pay the money. If I do not go, the petrol pump can forfeit my property and also get it transferred. The very moment that it exercises the right of forfeiture, I lose the ownership and somebody else becomes the owner of such property. Forfeiture is a surrender and confiscation. There is a slight difference between forfeiture and confiscation. Forfeiture is a surrender. Confiscation is a taking under any authority of law. The correct usage is that he forfeited the possession to the bank. So when I lose my ownership of the property, bank forfeit that property. So it is a forfeiture. Confiscation is taking of possession by claim of a superior right. For example, under GST, in case I am caught carrying the goods without payment of GST or violating any provisions of the GST, government has the government authorities, the GST authorities have right to detain my property. They will call upon me to pay that much amount of tax and penalty. In case I fail to do that, they may confiscate my property. The government confiscated or seized somebody's smuggled goods or somebody's property is a confiscation. Whether it's a forfeiture or a confiscation, anyway, transfer of the ownership of the property takes place without the act of the actual owner, without any consent of the actual owner. Now let's get closer to the Transfer of Property Act. Transfer of Property Act, Section 5 to 37 lays down certain general principles relating to transfer, both movable and immovable property, and 38 to 53A deal with various specific transfers such as sale, lease, license, mortgage, etc. relating to immovable property and of actionable claims. And then, of course, there are certain other details. I think Chapter 2 is divided into two parts. A Part 1 deals with principles which are applicable to transfer of both immovable and movable property. Then this chapter provides certain general rules as to transfer of property. Then Part B of Chapter 2 embodies certain rules relating to immovable property. And then, of course, we will study some specific kinds of transfers under the immovable property. Chapter 3, sale, Chapter 4, mortgage, then Chapter 5, lease, and then exchange, gift, and transfer of actionable claim. That's how the structure of the enactment is there. Let's now come, now onward, we will be dealing more with the only Transfer of Property Act and not anything else. Properties which can or cannot be transferred. Can all kinds of properties be transferred? Section 6 of the Transfer of Properties Act says that, as per Section 6, it says property of any kinds may be transferred except as otherwise provided. And where the provision will be made, it could be provided under the Transfer of Property Act itself or by any other law for the time being in force. So there could be two situations. One, I'm going to deal with you in Section 6 itself, which provides that certain kinds of properties cannot be transferred. Or there could be some other law which also might restrict or prohibit the transferability of properties. For example, during the course of insolvency, an insolvent person is prohibited from transferring of his or her property. Now let me first take up with you that what are the kinds of properties which cannot be transferred under the Transfer of Properties Act. It says the following, section 6 again says the following properties cannot be transferred. One, chance of a heir apparent. Who is heir apparent? Heir apparent is a right to succession. Uttradhikar. I might become the successor of somebody's property, or if not anything, at least my parents' property, I will be successor. Someday I'm likely to acquire my parents' property. But in anticipation of the fact that I will be acquiring that property, as an accountant, I might be able to calculate even the present value or the probable present value of that property. But can I transfer that today? While I'm likely to, I have some probability or 100% probability of acquiring my father's property, but can I transfer it today? It says the chance of someone obtaining the legacy of the death of a kinsman is a chance of a heir apparent. It says any mere possibility of a like nature cannot be transferred. The chance of a heir apparent means if I'm likely to acquire somebody's property or somebody's property will come in succession to me, however large the probability of my acquiring may be, I cannot transfer it till property actually gets transferred to me. A mere right of re-entry for a breach of conditions subsequent. Say I am a landowning agency. I have given a large chunk of land to some factory owner for the purpose of running of a factory, and where I also specify the object of transferring is to run a factory, say an automobile factory. Land will be used only for setting up of a automobile factory and for no other purpose. And I also write in a paragraph in the agreement that in case of any violation or any misuse of this land or the use of this land for any purpose other than the prescribed, the leasee will lose the right to leasership and the property will revert back to me. And this reverting back of the property in the case of a breach of a condition which has been imposed upon the leasee is a right to re-entry. Can I transfer this? And there could be some probability of the person violating the law, and as a result of which I became beneficiary of becoming a re-entrant to that property. Can I transfer this? I cannot transfer this to anyone except to the owner of the property affected thereby. So that's again given in section 6 itself. At times, friends, you may find me becoming a little technical, or if I may use the word little too technical. Don't hesitate at all. Don't just keep quiet or koi kya sochega, ye mere ko nahi aata hai. Don't worry at all. Please feel free to ask. It is better to expose myself to an ignorance rather than just keep sitting when I do not understand a particular topic. You have understood what is an easement? Easement, in the beginning I said, is a right to cross over or somebody's land. When I have a plot of land or when I have a flat, so in order to beneficially enjoy that flat, I not only get the right to flat, I also get the right of easement. That means I have a right to cross over, say, government land, a road, a street, a park, some narrow passage, as a result of which, and all those narrow passages, road, street, through which I can pass is called an easement. And easement is normally attached with a dominant heritage. Can I continue to own a plot of land and a flat, but at the same time I say I don't want to sell this plot or a flat, but I want to sell the benefit which is attached to, that is easement, I want to transfer. So Transfer of Properties Act says that any easement or any right to cross over cannot be transferred except along with the dominant heritage. So if the plot of land and the flat is my dominant heritage, and the right to pass over somebody's land is an easement, so easement cannot be transferred separately from the dominant heritage. Like that, an interest in a property restricted in its enjoyment to the owner personally. So there might have been some settlement of a property by virtue of say I am a female member of the family where I have been given right only to stay on so long as I am alive. So that right has been given to me, and that right is limited to enjoy that property during my lifetime. But can I transfer this? Because I myself have a limited right that cannot be transferred. So interest in a property restricted in its enjoyment to the owner personally cannot be transferred by him. Right to future maintenance is again is something which comes out of normally out of a family settlement when brothers and sisters divide the parental property amongst themselves, and some of them willingly takes over the obligation to maintain the parents in future, and the parents have got a right to future maintenance that may have some monetary value. But even if such a right to maintenance has a monetary value, that cannot be transferred. Like that, a mere right to sue cannot be transferred. So uh, you and I have entered into any contract where you find that I have committed some breach of contract by virtue of which you can sue me and take certain advantage, take a decree or a court's order against me, but you don't want to get into this hassle. But can you transfer this right to sue? No, it cannot be transferred. Like that, friends, a public office, the position of authority or a service involving responsibility of a public. Say, I am a member of the parliament or I am a member of the state assembly. So can I transfer my position? That's a public office I am holding. Can I transfer this? No, it cannot be transferred. Like that, friends, salary of a public officer, whether before or after it becomes due, cannot be transferred. Stipend allowed to military, naval, or air force personnel, or of the civil pensioners of the government, or of the political pension, they also cannot be transferred. Then fraudulent transfer cannot take place. Every transfer of immovable property made with the intent to defeat or delay the creditors of the transferor shall be voidable at the option of the creditors defeated or delayed thereby. So I know that I have a lot of creditors hovering around me, and and they will get a court order to get my property attached, and in anticipation of that, in order to prevent that kind of an attachment, I transfer my property to XYZ, and such a transfer will also be voidable at the option of those creditors who have already might have made an application to the court of law. But here, friends, I would like to just do a little caution. Here, it will depend whether the buyer is aware of this situation or not. In case the buyer buys that property without the knowledge of the fact that I am trying to transfer my property with the intent to defeat or delay the transfer, then if buyer is aware, then he will not get a good title of my property. But nothing in this subsection shall impair the right of a transferee in good faith and for a consideration. If the buyer is not aware the main purpose of my selling, in such cases, the buyer will get a proper, and he's buying in good faith and for a consideration, then his right will not be vitiated. Then the present creditor will again apply to the court of law in seeking some alternative remedy. I'm sorry. Is it sounding interesting, friends? जो भी टॉपिक हम आज कर रहे हैं, whatever topic we are covering, is it sounding somewhat interesting or very boring?
Interesting.
It's interesting. I'm glad. And some of you have studied this topic before. I think some of you must be chartered accountant, cost accountant, or lawyers. Anybody who is a chartered accountant or a cost accountant?
Yes, sir.
I am a chartered accountant.
Great. Then for you, it must be like a learning of the alphabets. You must have already studied this at a fairly good length. And if some of you is an advocate, you might be practicing and might be having much deeper knowledge than I have on the subject. Any of you is an advocate? Only chartered accountant, cost accountant. Okay. Company secretary? Doesn't matter. Let's not waste time. Okay, friend, who can transfer the property? Can anybody and everybody transfer property? Now we come to next section, that is section 7 of the Transfer of Property Act. It says every person who is competent to contract. So basic elements of the competency to enter into contract should be there, which means he should be not be a minor, he should be person of a sound mind, he should be not have been deprived under any law from entering into contract. So that's how the competency to enter into contract arise. There has to be, in order that whether I am competent to contract or not depends upon three things. That is, I should not be minor, I should not be person of an unsound mind, so I should be a person of a sound mind, and I should not be debarred under any law from entering into contract. So every person who is competent to contract and is entitled to transferable property. But that means entitlement means I cannot transfer, say, old fort in your favor or anybody's favor. Can I do that? I cannot transfer that because I am not entitled to transfer. Can I transfer your car to say XYZ? No, I cannot do so because it is your car. I have no entitlement to transfer property. So in order to transfer, number one, I should first be person competent to enter into contract. Second thing should be I should have entitlement to transfer property. And this entitlement should normally come from the ownership of the property. If I own a property and if I am competent to enter into contract, contract, then I can transfer property. Or if I am competent to contract but do not own a property, can I still transfer? Yes, there can be some situation where the transfer may take place by known owner, which means I am authorized to dispose of property. Somebody has given me a power of attorney, or somebody has authorized me under any law, or I am a mercantile agent by my trade or profession, then also I can transfer property. So as a mercantile agent or an authorized representative, as a power of attorney holder, I can transfer somebody's property provided I have been duly authorized by that person. Competent to transfer such property is a competent, yes, so there should be two things. One is the person should be competent to contract, another should be he should be entitled to transferable property, or he should be authorized to transfer property. Such a person only can transfer property. Hence, every person competent to contract and having ownership can transfer property, or any person who is competent to contract and having authority to transfer property, such as agent or a mercantile agent, such person can also transfer property. So, and once I know that what is property, once I know it can or cannot be transferred, in case everything is pakka and now I can transfer property, what is the manner of effecting the transfer of property? What is the procedure I should follow? That what is the steps I should take in order to transfer property? Manner of effecting transfer of property. Property can be transferred either orally or by writing. And the Transfer of Property Act also decide what kind of a property can be transferred by mere delivery or orally without even entering into any written contract, or what kind of a property is there for which some legal formalities or procedures are required to be followed. It says property, movable property can be transferred by delivery of possession or by registration. Pakka decision. So any kind of a movable property, say a car, even if I want to buy very costly movable property, say 50 kg of gold, or maybe I want to buy from you, say 10 kg of ganja or chars or something. All these are, by now we know, movable property, and they can be transferred by simple delivery. Hold. I want to caution you, while as far as the Transfer of Property Act is concerned, there is no restriction on transferability of immovable property, transferability of movable property, because by any nature, movable ownership of the movable property, or lease or a license or a mortgage pledge or a hypothecation of a movable property can be done by simple delivery. But there could be some application of another law. I gave an example of a transferring of a car. It is a movable property. I just give you the key of the car and also tell you take this car and give me the money. And you may give the money and take the car. But do you become the owner of the property? Yes. As per the Transfer of Property Act, you may become owner of the property, but there is an application of Motor Vehicles Act. Under the Motor Vehicle Act, in order that you be own a car, you have to get itself registered, not with the registrar or sub-registrar of property of the Revenue Department, but you have to get this registered with the State Transport Authority. So when you read the Transfer of Property Act alone, any transfer of a movable property can be done either by simple delivery, giving of a possession, or you also can want to enter into a contract for, say, purchase of raw material. And for purchasing of a raw material is a movable property. You can have only an oral contract, need not be in writing itself, but you want to make sure that over a period of time, whatever raw material you receive, you want to enter into an agreement. You want to get that agreement registered also. So there is no prohibition. You can also get an agreement relating to transfer even of a movable property in writing, or you can also get such an agreement by registration. You can also get that agreement registered. Law does not prohibit registration. I also gave some bad examples of, say, transferring ganjas and hashish and those bad kind of things which are in the news these days. They are all movable property. As far as Transfer of Properties Act is concerned, so that's a that can be transferred. But as far as some certain drugs and psychophantix acts and other enactments are concerned, that transfer, sale, marketing, transportation might totally be prohibited. In such cases, if I do so in the violation of those enactments, then I might be prosecuted, I might be convicted, I might be penalized. So those follow-up action will be there. But as far as Transfer of Property Act is concerned, there will be no prohibition onto that. Now let's come to how the immovable property can be transferred. Section 54 of the Transfer of Property Act says transfer of tangible immovable property of the value of 100 rupees and upwards can be made by a registered instrument. So friends, in case you have any immovable tangible property which has a value of less than 100 rupees up to 99 rupees and 99 paisa, you can transfer it by simple delivery or by an agreement in writing. But in case you have any immovable tangible property of the value of 100 and upward, then you must do it can be made only by a registered instrument. Registered instrument means there has to be a sale or an agreement to sell in writing, and it has to be registered with the registrar of the Revenue Department. So a tangible immovable property of the value less than 100 rupees may be made by either registered instrument or by delivery of the property. And the tangible property means a property which can be touched physically and hence capable of physical dealing. Intangible property means something in abstract, not capable of being touched or perceived, and yet have certain values such as copyright, goodwill, license, those kind of things. Now, how can intangible property be transferred? Intangible property is traditionally divided into pure intangibles such as debt, intellectual property rights, and goodwill, etc. So normally these can be done by agreement in writing. So in case there is a intellectual property right, so you can do it under the Intellectual Property Right Act. There must be some restriction onto that. Like that, in case there is a goodwill, normally you will enter into an agreement in writing. But in case there are documentary intangibles, such as you have some promissory note, bill of exchange, bill of lading, so they can be transferred under the law in which they are drawn. Say in case you have a check, promissory note, or a bill of exchange, all the three come under the Negotiable Instrument Act. And how these three instruments can be transferred from one person to another, depending upon whether such instruments are order instruments or they are bearer instruments. In case they are bearer instrument, they can be transferred by simple delivery. And in case they are order instrument, they can be transferred by endorsement and delivery. But we are more concerned with only transfer of immovable property. And now onward, I will try to have greater focus on the transfer of immovable property only. In the transfer of immovable property, there are two terms which will often be using: executant and execution. Executant means if transfer is made, whenever the transfer takes place by in writing, the person who signs the document is called executant. That means in case of a sale of an immovable property, buyer and the seller shall be executant of the sale deed or a conveyance deed. And the process of putting their signature or fixing their signature by virtue of which the transfer take place or confirming the transfer is called process of execution. And in case such an execution has to be done by an illiterate person who cannot write not even his signature, he can put his thumb impression and he may direct some literate person to sign it on his behalf. And in that case also the transfer shall be valid. Now friends, let's try to recapitulate what we have covered. We wanted to cover the Transfer of Properties Act in total. And in that process, we studied as to what is property. In that process, we also knew what is movable and immovable property. Then we knew what is transfer, what can be transferred, what cannot be transferred, who can transfer, what are the qualities or the qualifications for effecting transfer of an immovable transfer of any kind of a property. Then we also knew there could possibly be all kinds of transfer fall into two categories, that is transfer by operation of law, such as execution, insolvency, succession, etc., and by act of the party. And in the act of the party, we also knew transfer of movable property and transfer of immovable property. So by now I have covered nearly 2/3 of the Transfer of Property Act, or maybe little more than half of the Transfer of Property Act. In case there is any question, please feel free to ask me. Anything you want to ask, feel free to ask me. Otherwise, I take you to certain specific kinds of transfers such as sale, mortgage, charge, lease, license, exchange, gift, actionable claim. Sale.
There's a small question.
Yes.
Hello.
Yes, madam.
Yeah, it will be really nice of you if you can just pinpoint like which sections are more relevant in respect to the exam of like valuation.
Okay. As far as exam is concerned, madam, out of the entire topic that we covered today in 2.5 hours, this Transfer of Property Act and also the Stamp Act, I was told that you will be getting anything between 6 to 7 marks. Entire syllabus that we will be covering between 9:30 a.m. to this morning till around 12 today, entire thing will be between 6 to 7 marks. And if it will be multi-choice questions, it's very difficult to pinpoint as to what question they may ask. Otherwise, I would have just given you those 6 questions on a word sheet, and matter would have ended. You would have got all 6 out of 6 or 7
Yes,
out of 7.
yes.
So, but one thing I can assure you, that in case you are enjoying the study of this topic, and since you have already studied this, plus you are revising it today, plus you will do some more preparation, this will be definitely help you in your day-to-day performance as a registered valuer. Okay. So rest of the topics are very easy. I will do, in case no questions are coming, let me do the rest of the syllabus in a pretty fast forward mode. We are trying to start with the sale. The first kind of a transfer is sale. I told you that while transfer is a big term, it involves sale, lease, license, mortgage, all kinds of transfer. Sale is only one kind of a transfer. So sale is transfer of ownership in a property in exchange for price, paid or promised to be paid, or partly paid and partly promised to be paid. I think it's a very similar definition as is given the definition of sale under the Sale of Goods Act. It means transfer of ownership. But if you are transferring any right less than that of the ownership, so if you are mortgaging the property or leasing the property, it will not be a sale. And another characteristics of the sale is the price should be either paid, which means you have already received the price at the time of transferring the ownership of the property, or you should be making a credit sale where you are transferring the property today, but the buyer will pay you over a period of time, or he is only promising to pay you. You are making a credit sale of a immovable property, or it could be partly paid and partly promised to be paid. So part of the money you are getting today, part you will be getting after some time. So essentials of the sale is seller must be a person. This I'm not be repeating. The first point will be everywhere. It will be there. Is a general provision of the Indian Contract Act that whatever you do in the commercial world, you can successfully do it only when you are competent to contract. That means you should not be person of a unsound mind, should not be minor, should be major, and should not be debarred from entering into any contract. Buyer must be any person who is not disqualified to be a transferee. That means he should also be a person and capable of entering into contract. Subject matter of sale is transferable property, which means you cannot transfer right to sue, you cannot transfer the chance of a heir apparent, you cannot transfer a easement without the transfer of a dominant heritage. So those restrictions will be there. There is a transfer of ownership. So in case you do not transfer ownership, only give it on a lease or a license or mortgage, then it will not be a sale. Then it must be an exchange for a price. That means you should get something which is a legal tender, which should be a money. If you transfer, say, product A for product B, or you are transferring an immovable property, your house, in exchange for a luxury car that you might be getting, there is an exchange.
Sir, please, explain please the dominant heritage in detail.
Dominant heritage, say, whenever you own or acquire an immovable property, you think that you have only acquired that plot of land or maybe a flat. And that flat or a plot of land is called a dominant heritage. In relation to that dominant heritage, unconsciously, you also acquire the right to approach that dominant heritage. This could be by way of a road, this could be a part of the street, or sometimes your land could be located in such a manner where you get an exclusive right to approach that piece of land. That is called easement. So I said that easement cannot be transferred without the transfer of a dominant heritage. You cannot say, I will continue to have my plot or a flat, but I only transfer my right to cross over somebody's land in order to enjoy that flat. That's what the easement and dominant heritage are quite closely related. You can transfer easement only when you transfer the dominant heritage. Now, is it clear now? Sir, is it clear?
Yes, sir, it's clear now.
I'm glad. I'm really happy that your satisfaction is my purpose of being here today. Okay. If the consideration is not money, but some other valuable consideration, so under the contract, you know that consideration need not be necessarily monetary consideration. It could be consideration in kind also. If there is a consideration in kind, I gave an example that you transfer your immovable property in exchange of you are getting a luxury car, and transfer of one kind of a property for another kind of a property, it could be a exchange or a barter, but it will not be sale. So the consideration must be in monetary terms only. Then contract of sale of immovable property. So a contract of sale of immovable property differs from contract of sale of goods in that the court generally can grant a specific performance of it unless the special reasons to the contrary are shown. Generally, whenever you agree to purchase any flat, you not only pledge just one out of many flats, but you also have in mind the location of the flat, whether it's a sun facing, whether it's a road facing, whether it's a market or a park facing. So whenever you enter into this kind of a contract, and in case the seller is in default, only monetary consideration may not be enough for you. You may ask the very specific performance of a contract. You may apply to the court that you want to buy that flat only because that flat is more suitable to you according to some shastra or some myths that you might be having about it. In such cases, normally in the case of a immovable property, court allows specific performance of a contract. But in case you agreed to buy certain number of shares or certain number of say cycle or certain number of other things, the court may only allow you the compensation and need not necessarily the specific performance of a contract. Then the probability of the court awarding specific performance of a contract in case of sale of immovable property is much higher. Now, having understood the term sale, so the rights of liabilities of the buyer and the seller. Normally, in the case of a sale, buyers and sellers have full freedom to enter into contract as to the price at which they will be selling, the terms of payment, whether it's a credit or a cash sale, at what time the delivery will be done, whether it is a property as it is, where is as is, or it is subject to certain fulfillment of obligations by the seller, so that the parties are free to enter into their own terms of sale or purchase. And wherever there are no terms, then the rights and liabilities of the seller and buyer are dealt with in Section 55 of the Transfer of Properties Act. Let's take up now duties and liabilities of the seller. Very easy. Disclose to the buyer any material defect in the property or any material defect in the title of that property of the seller. If the seller is having a defective title, that means he might have forged the signature of some previous seller. In such cases, he will be having a defective title. The previous seller whose signatures have been, who was not a seller as fact, whose signature were forged, in such case, it is the duty of the seller to disclose it to the buyer. Like that, to produce to the buyer on his request for examination all documents of title relating to the property which are in the possession and power of the seller. I think I can go on quickly reading these, but wherever you find that some term need a clarification, please hold me. To answer to the best of his information all relevant questions put to him by the buyer in respect of the property or its title. Whenever buyer wants, where do you buy the property? Are you the original allottee of this land or a flat? Did you take it in succession? Did you buy it from the secondary market? So all those things buyer will be curious in asking as a part of his due diligence. So it is the duty of the seller to disclose those things. Then on payment or tender of the amount by the buyer to execute a proper conveyance deed for the property at the agreed time and place, and between the date of agreement to sell and the date of delivery of the property, he has to bear all the expenses relating to the maintenance of property, and he has also to pay all expenses such as water and electricity payments, house tax, any municipal tax, or any lease money which might be payable, so up to the date of actual transfer, if a seller has an obligation. To give on being so required to the buyer or to such person as the buyer directs, such possession of the property as the nature admit, and to pay all public charges, taxes, rent accrued due till the date of sale. What are the rights of the seller? Rights of the seller are to rent and other profit from the property till the ownership passes. So property might be given on rent, and till the date of the transfer, it will the right of the seller to receive it. After the date of transfer, buyer will start receiving it. In case of possession of the property is delivered without full settlement of the consideration, that means credit sale was made, seller is entitled to the balance consideration as well as interest on such consideration depending upon the type of contract they have entered into. Then like that, duties and liabilities of the buyer is bound to pay or tender at the time and place of completing the sale the purchase money. But at the same time, if the buyer is aware, buyer comes to know that the said property has certain encumbrances, he can hold the money to the extent of such encumbrance. So he knows that on the property, some house tax is not paid, or at the time of entering into contract, he knows that property is mortgaged or mortgaged to some bank or a financial institution and some outstanding loan is there. To that extent, buyer can hold the money. Then the duty of the buyer also is where the ownership of the property has passed to the buyer. Uske baad ke after that, all the expenses arising out of the destruction, injury, or decrease in the value of the property shall be on buyer's account. Then wherever the ownership of the property has passed to the buyer is subject to encumbrances, so he can hold the money involved in that such encumbrances. I have already said about this. Right of the buyer will become the whatever obligation of the seller we have studied in the previous slide will become the right of the buyer, and whatever right of the seller we have studied in the previous slide will become the obligation of the buyer. And with your permission, I would like to skip this slide, or in case just have a look at it in case you feel that some of the point require clarity. I will be willing to speak a little bit on that. Shall I go to the next stage? Yes, shall I?
Yes, sir.
Okay, thank you. What is exchange? When two persons, in the beginning I said as a distinction between sale and exchange. Whenever the consideration in transfer of the property is money, then it is a sale. And when two persons mutually transfer the ownership of one property for ownership of another property, neither or both being money only, the transaction is called an exchange. And essentials of the exchange are the person making the exchange must be, this you will read it everywhere. There must be a mutual consent of the party. There is a mutual transfer of ownership, even though properties and the interest in the property may not be identical. So I might be selling you a freehold property. In return, you might be giving me a leasehold property. So properties are not identical, but still it is by the party they can enter into. Still there will be an exchange. Neither party must have paid money. If they have paid money, one of the party have paid money, then it will be sale, otherwise exchange. So rights and liabilities of the parties exchanging. Each party that has a right and is subject to liabilities of a seller as to that which he gives. So I am giving something and in return I am taking something. Whatever I am giving, I have rights and obligations of the seller, and in return you are giving me something, I have rights and obligations of the buyer. So the rights and is subject to the liabilities of the buyer as to what he takes. So they're very similar. So same previous slides you will be rereading. So the same become the rights and the obligation of the exchanging parties. Manner of the exchange will be the same as that of a manner of a sale. In case in exchange we are giving only movable property, then such a transfer can take place by simple delivery. And in case one or more of the item given in exchange is involved immovable property, and that has a value exceeding 100 rupees or more, then such a exchange also can take place only by way of an agreement in writing duly registered. Up to this, friends, we have completed sales. Now we try to cover mortgage. What is a mortgage? You must be already aware about the mortgage. Section 58 of the Transfer of Property Act define mortgage as transfer of not the ownership in a immovable property, but is a transfer of an interest in a specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of a loan or an existing or a future debt or the performance of an engagement which may give rise to pecuniary liability. So friends, it's not a transfer of ownership, it is only a transfer of interest in a specific immovable property. Mark the word immovable property. If it is a transfer of interest in a movable property, then it may be a pledge or it may be hypothecation. But if it is a transfer of interest in an immovable property, then it is a mortgage. So mortgage is only in respect of immovable property, not that of a movable property. Then the purpose of mortgage also must be That's either securing the payment of money. That means I am borrowing money today. In return, I am mortgaging my immovable property with you, or I am mortgaging my immovable property with you in return of what money you have already advanced it to me, or you have still to advance it to me. So I just give an example. You might have given me some loan, unsecured loan. I am not able to pay that loan in time, and I want you to extend the period of repayment of that loan. And you say, Mr. Khurana, earlier also you have been defaulting. Now I cannot extend the time. You are already having the money. I will extend the time only when you mortgage some of your immovable property. So the money has already been advanced or to be advanced. Sometimes I create a mortgage in your favor in return of you are agreeing to give me the money maybe at some future point of time. So that can also be possible. Or it could be an existing or a future debt, or it could also be performance of an engagement which might give rise to pecuniary liability. Say I approach you that Mr. Such and Such or Master Such and Such, you are a company, and please engage me, employ me as a cashier in your company. You say, yes, we also need a cashier, but Mr. Khurana, how do we know that you will not run away with the cash? So in order to have satisfactory or safe performance with you, we want you to mortgage your immovable property with us, so that in case you run away with our cash, we should be able to exercise our right on the mortgage property. So their purpose could be either securing payment of money which has been advanced or yet to be advanced. It could be in order to secure the existing or a future debt, or it could be in order to secure the performance of an engagement, and such engagement which may give rise to the pecuniary liability. So in all these cases, there will be a mortgage of an immovable property. In the mortgage of an immovable property, there are generally two parties, that is mortgager. Anybody, the borrower is normally the mortgager who gives the property in mortgage, and the person transferee in whose favor the property is transferred is called mortgagee, and the principal money and interest for which the mortgage is created is a mortgage money. And the agreement, written agreement, normally since it will involve immovable property and of a value exceeding 100 rupees, there will be mortgage deed, and the mortgage deed will have to be registered. Essentials of a mortgage: transfer of interest in a property, not the transfer of ownership of a property. Specific immovable property should be there. Secure the payment of loan or a performance of an obligation. There are 6 types of mortgages. That is a simple mortgage, the simplest to understand. The property continues to be in the possession of the borrower, that is mortgager. Only a personal undertaking is given by the borrower, acknowledging the loan, that he has taken a loan, and agreeing to repay as per the schedule or as per the terms agreed. And with this, there is also an understanding that in case the mortgager fails to pay the money, then the property, immovable property, shall be available to the mortgagee, and the mortgagee can exercise right on such mortgaged property. This kind of a mortgage normally take place when the property has, normally I'm saying, but there could be other situations also, when the property has not reached the hand of the buyer. Whenever you want to borrow money under the mortgage of a house or a flat which you have yet to get from a builder, then you pay the application money, make an application with the bank, and through the bank you say the house is still under construction, and the bank will be paying the EMI, and there is an agreement that as and when the property, immovable property, comes to your hand, then you might, there might be a term when you will complete the mortgage, or there may not be any term. The bank is so much trusting you that he is willing to lend you the money even without deposit of a title deed. Title deed, ownership, possession, everything remains with you. Only your commitment has gone to the bank that in case you fail to pay money, then the bank will be in a position to exercise that right. The next is the mortgage by deposit of a title deed, in which where the original title deed, title documents of the property are deposited with the mortgagee, that is the bank, or his agent as may be specified them. This second kind of a mortgage is more secure in favor of the lender than the first one. You know that once you deposit the original title deed with the lender, then you cannot deceive that lender by entering into a similar kind of a mortgage with another person. And in such cases, you default on both the side, and both the mortgagee will run after that property. Both of them will get into dispute. They will not be able to realize that. They may find it extremely difficult to realize that money. Third kind of a mortgage is English mortgage, where the mortgager absolutely transfers the mortgage property with absolute ownership rights also. That means the ownership of the property itself is transferred, but the agreement of the mortgage deed provides that in case the borrower repays the money on time or as per schedule, in such cases, the mortgagee will return that property to the mortgager. So in this case, first of all, ownership is transferred to the mortgagee with the intention to create the mortgage, and also commits to repay the amount on certain time or certain installment. The absolute transfer is done subject to the condition that the transferee will return the property on repayment of the debt by the mortgage. So that is the English mortgage. Next is usufructuary mortgage. Usufructuary means the right accorded to a person to use and enjoy income from that land or from the immovable property, or benefit from someone else's property. In this case, the immovable property belongs to the borrower. He only gives it on mortgage, but the terms of the mortgage may provide that during the course of the mortgage, the physical possession of the property will be handed over to the mortgagee. Then in case it is an agricultural land, the mortgagee can grow its crops and enjoy the benefit. In case it is a building, the mortgagee can give that property on rent and continue to collect rent in addition to some interest that he might be getting, or he may even enjoy living in that house. So that's called a usufructuary mortgage. Then mortgage by conditional sale is exactly vertical or exactly reverse or opposite to the English mortgage. In the case of an English mortgage, ownership was transferred right at the time of entering into a mortgage deed, with the condition that in case money is paid on time, the mortgagee will return the property to the mortgager. In this case, ownership of the property continue to remain with the mortgager, but there is a condition provided in the agreement that in case the mortgager fails to pay the or return the money, borrowed money on time or as per the schedule, the lender or the bank will have a right to exercise ownership over that property. So just opposite of the English mortgage. So in English mortgage, the ownership in the mortgage property is absolutely transferred to the creditors. But in the case of mortgage by conditional sale, the mortgagee gets only qualified ownership, which may, however, ripen into absolute ownership in the event of the default by the mortgager. There is another, you can also customize the mortgage by having elements of various kinds. You have studied so far the 5 kinds of mortgages. You can also customize it according to your requirement. What anomalous means deviating from what is standard or a normal expected. A mortgage that does not fall into any of these categories would be a anomalous mortgage. For example, mortgage where possession of the mortgage property remains with the mortgager, but in order to have also the elements of element of what is called a structural mortgage, the mortgager may start paying certain rent out of that or certain portion of the crop grown on that property or land. So friends, right of the mortgager and the right of the mortgagee, both mortgager and the mortgagee are free to enter into their terms and conditions of the mortgage. And wherever there are no terms, the general principle of the Transfer of Property Act will apply, and the mortgager invariably will have 3 rights. That is the right of redemption of the property, because the nature of the contract of mortgage is transfer of interest in a property for the purpose of borrowing money or securing performance of a contract. In such cases, the mortgagor have a right to redeem the property after he has repaid the amount as per the terms of the mortgage. Then the right to transfer mortgage property to the third party. This is again subject to the terms and conditions. Normally, whenever there is a contract for a mortgage with a bank, bank definitely insists for a clause that during the course of this mortgage, the owner or the mortgagor will not transfer or sell the mortgaged property. Mortgaged property will continue to remain unencumbered with the mortgagor. But in case there is no such specific provision, the mortgagor can also transfer property to the third party. Then right of inspection of the property and also of the production of the document. At any point of time, mortgagor want to inspect the property mortgage, so he can do so. He can also inspect the documents which have been mortgaged with the mortgagee. Then he has a right to accession. Accession means he can access that property at any point of time. He can also have improvements over the property in case the property is in a dilapidated condition, or he want to construct one more floor over it. So he want to bring about some improvement, get a whitewash done, he can do that. Then right to renew the lease in case the property has been leased to somebody and it is mortgaged with somebody else, so he can renew the lease. Obligations of the mortgagor. So it's a obligation of the duty of the mortgagor to preserve the property and should not let it to go into dilapidation or downfall. Then duty to indemnify the mortgagees for defective title in case he had a property under a defective title, means he has forged somebody's signature and shown his property, shown that property as his, whereas actually it might not be. Then he has to compensate the mortgagee for any loss that the mortgagee may suffer. Duty to compensate mortgagee for any loss as a result of his negligence, so that is also there. Charge is also similar to that of a mortgage, but it is slightly different. Section 100 provides the definition of a charge, where an immovable property of one person is by an act of the party or by operation of law made a security for payment of the money to another, and such a transaction does not amount to mortgage, the latter person is said to have been having a charge. So one of the major difference you get to know about between the mortgage and a charge is mortgage is always by way of act of the party, but the charge may get created without the act of the party. Say, for example, if I do not pay my taxes on time, the statutory authority, the government authority may always have a charge over my property. They may attach my property, they may confiscate my property, get my properties resold. So even if they do not confiscate it, they can always have a charge over my property. But mortgage can never be by operation of law, it is always by act of the parties. Then a charge comes into existence either by this I have already taken up with you. Then charge by act of the parties, so can be where you enter into create a charge. In the case, particularly creation of a charge is more popular in the case of body corporates or a company, when you can create a floating charge or a fixed charge, where fixed charge is created against a very specific movable or an immovable property, but floating charge is more in the nature of a hypothecation. When you enter into a hypothecation agreement with the bank, physical possession of the property in case of a charge continue to remain with the person who creates a charge, and the lender can only exercise its charge only in the event of the default in the repayment of debt as per the terms agreed upon. Then charge by operation of law, I have already said that in case of any default on payment of tax or on any violation of any law, the statutory authority can exercise charge over my property, but they cannot exercise mortgage over my property. Mortgage is a transfer of interest in a property made by the mortgager as a security, while charge is not transfer of interest in a property, though it is a security for payment of an amount. Then the charge may be created by the act of the party or by operation of law. So friends, what is gift? The essential element of the gift is the transfer of movable or immovable property made voluntarily without any consideration by one person to another. Person who transfers is called a donor, and the person to whom the property is transferred is called donee. The essential feature is it should be without consideration. And another essential feature of a gift is it should be accepted by or on behalf of the donee. And such an acceptance must be made during the lifetime of the donor or while he is still capable of giving. I give an example. I gift you certain, say, movable property. At that time, you do not give your consent. And to maybe after 15 days, I die. And at that time, you want to exercise this consent. That now you say, okay, Mr. Khurana has gifted me this property on, say, 28th of August. Now that he is no longer there, so I want to exercise. Since he has gifted it to me, now I want to accept it. No, you cannot do it. You can accept it only when during the lifetime of the donee or during the lifetime when he is still capable of giving. There could be another example where I gift you certain movable or an immovable property, do not accept it, you do not accept it, and after 15 days, I become a person of an unsound mind and incapable of giving. At that time, you say, okay, I convey my acceptance. You cannot convey your acceptance at the time. You can convey your acceptance only till I am alive and till I am capable of giving. And if the donor dies before the donee's acceptance, the gift will be void. Essentials of the gift are there must be transfer of ownership. The gift cannot be by way of a lease or by way of a mortgage. The subject matter of the gift must be certain existing movable or immovable property. Transfer must be voluntarily without consideration. It should be accepted by or on behalf of the donee, and acceptance must be made during the lifetime of the donor or while he is still capable of giving. Next kind of a transfer is lease. According to section 105, lease of an immovable property is transfer of a right to enjoy property. That means you are an owner of the property, but you do not want to enjoy that property. You want some money and you want to transfer the enjoyment of the property to a person called leasee or a tenant. And since it is a transfer to enjoy and use property, possession of the property is always given to the transferee. And the lease immovable property must be made for a lease of a immovable property must be made for a certain period, 1 year, 2 years, 3 months, 6 months, or whatever it is for the period. And the lease of the property is given for a definite period, that is the number of years, months, or days, or you can also give a property on lease for a life or on a perpetual lease. And when you give a property on a perpetual lease, that means you continue to be leaser for all times to come. And after you are not, I'm sorry, I'm using bad word, forgive me. Even when you are not there, your successor will continue to remain the leaser of that property, and the lease is transferable. That means that it is inheritable and can be taken in succession. Essentials of the lease is the transfer of right to enjoy property. Such transfer is for a certain period of time or in perpetuity. It is for a consideration which is either paid or it could be by way of a premium, certain lump sum amount taken now and the property given later. Parties to the lease are leaser and the leasee. The transfer must be accepted by the leasee or a transferee, and the transfer is a transfer of interest in a property. Then there are obligation of the leaser and the leasee. Many of you must have entered into an agreement either as a leasee or as a leaser. You know that you are always at liberty to decide your own terms of the lease. How much will be the lease rent payable, for what period of time, what will be the terms of getting it vacated, how much notice should be required for termination of the contract, who will be responsible for maintenance of the building, what kind of a maintenance will be done by the leaser, and small maintenance like water taps and other might be done by the leasee. So you can, what will be the escalation clause, at what periodicity the lease money or rent will be increased, whether you agree for any security or not. So those, all those things that as a leaser and the leasee, you are free to decide your own terms of lease agreement. But there are certain basic obligations of the leaser that he has to disclose any defect in the leased property or in the ownership of the leased property. He has to disclose, and the leaser is bound to the leasee's request to put him in the possession of the property. So leasee will become the get into the physical possession of the property. The leaser shall be deemed to contract with the leasee that if the latter pays the rent, then leasee can continue to enjoy the property without any interruption by the leaser. Right of the leaser are, he has a right to continue to receive money. He has a right to inspect the property anytime he feel like. So these are the rights he has. When does the lease agreement comes to an end? It can come to an end by efflux of time, by passage of time. If the agreement was for 3 years, after 3 years, or if it is for 5 years, after 5 years, or where the lease is for attainment of any particular objective, then the lease will come to an end on attainment of a particular objective. Or if the lease is contingent upon happening or non-happening of a particular event, then lease will come to an end on happening of a particular event, where the interest of the leaser terminates when the leaser has transferred the ownership of the property. Then also the lease will come to an end. In case of a interest of the leaser and the leasee stand vested in the same person. So today I have given my property on lease with you. Tomorrow I enter into a novation contract by virtue of which I transfer you the ownership of the property also. In such cases also lease will come to an end, or there could be express surrender by the leasee of the property, or by mutual agreement we may terminate the contract. License is very similar to that of a lease, except that in the case of a license, no interest is created in favor of the licensee. He is only allowed to have certain use about the property. He only has a permission to use the property for an agreed purpose. The difference between lease and a license is, in the case of a lease, it is always, it can be inheritable. It can, in case the leaser or the leasee die, if their successor, legal successor, will get the same right as that of the original leaser and the leasee. But in the case of a license, the agreement comes to an end either with the death of either the licensee or the licensor. Generally, the lease contemplates the following, that is, it could be for a term of perpetuity, but license is normally for a shorter duration of time. In both the cases, there is a payment of price paid or promised to be paid. In one case, we call it a license money. In other case, we call it a lease money. A lease is a transfer of interest in a specific movable property. A license is a bare permission to use that property without transfer of any interest. A lease creates an interest in favor of the leasee with respect to the property, but license does not create any interest. I have already said lease is both transferable and inheritable. License is neither inheritable nor transferable. License comes to an end with the death of either party, I have already said. Then lease is unaffected by the transfer of the property in favor of the third party, but license comes to an end with the transfer. I think leasee have a right to protect the property in his own right. Licensee have no such right. Actionable claim is the last thing. I have already given you the definition of the actionable claim. Means a claim to any debt other than the debt secured by mortgage of a immovable property or hypothecation or a pledge of a movable property or any beneficial interest in a movable property not in possession of the claimant. So areas of rent accrued, I think I gave an example also, provident fund extending to the credit of the member of the provident fund, money due under insurance policy. These are the examples of the actionable claims. And but these are not the examples of the actionable claims. Secured debt, mortgage deed, contract of hypothecation or a pledge, they are not actionable claims. How the actionable claim can be transferred? Transfer of an actionable claim can be effected only by execution of an instrument in writing signed by the transferor or his duly filed agent. And the transfer of the actionable claim shall be complete only upon execution of such instrument, but such instrument need not be registered. I think with this, friends, I complete my topic of Transfer of Properties Act. It's quite a long topic, and I remember in our LLB there used to be almost full-fledged paper on transfer of property and Indian Stamp Act, which we studied over a period of almost 6 months. But today I have tried to cover it in a matter of around how many? 1.5 hours. We started at 9:30 and nearly 2 hours. Yeah. In case you have any issue, please feel free to ask.
Yeah, good morning, sir. I am Sushant.
Yeah, please.
I have seen in the mortgage, you have
Yeah.
told that there is a right to improvement. Is the right to improvement is to be done by the mortgager or mortgagee?
Mortgagee will not, that will depends upon the terms and conditions agreed upon. Normally, mortgagee will not be interested in reconstructing. He is only holding, his purpose of holding the property is only to secure the repayment of his debt. In case he spends money on that property, from where he will get the cost of that spending. Normally, it is the mortgager who should be interested in the safekeeping of the property, because property is going to get back to him at the end of the mortgage. But there could also be a situation, there might be some terms agreed between the two parties, so those terms will prevail. But sometime in order to safeguard his own interest, in case the property get destroyed, say because of flood or in case there is a fire, and the mortgagee doesn't bother to preserve the property either out of flood or out of the fire, then from where shall he and how else shall he recover the money? Normally, these things are that terms can be decided by the parties between the mortgager and the mortgagee. What will happen under these circumstances? Normally, in the case of a leaser and the leasee, you generally find that in case the building is destroyed because of earthquake, fire, hazard, this and that, then what will happen? It is the duty of the leaser to set that right within this period. And in case he doesn't do so, then what will happen? Leasee have a right to break that agreement and ask for the compensation. Those kind of terms you can decide it amongst yourself. Anything more you want to ask?
I have a little confusion.
Pardon? Please.
In case of usufructuary mortgage, as well as the lease, any basic difference between these two?
A structural mortgage, the the terms of the mortgage. Why mortgage is done? Mortgage is done in order to secure the repayment of the money or ensure the performance of a contract. But in the case of a lease, there is no such purpose. Is not that. Purpose is that you have a property, you want to get some money out of it, some rental out of it, and somebody doesn't have a immovable property, he want to enjoy it. So you are a landlord, and a large tract of land you have. You don't want to get into the hassle of having to cultivate those fields. So give it on lease to the small farmer who give you assured income, right? But in the case of a mortgage, whatever kind of out of the 6 kind of a mortgage, whatever kind of a mortgage you want to enter into, so the purpose is to secure the repayment of the money. And mortgage is only one kind of a mortgage is a structural mortgage. And in case you do not give them the physical possession, you do not want to enter into that subset of a structural mortgage, then no issue. Then you can go into simple mortgage or mortgage with a deposit of title deed.
But here I have a point. In simple mortgage,
Yeah.
Basically, what I'm mortgaging, except one undertaking, I'm giving only one undertaking. But
Yeah.
mortgage generally means that, okay, I am keeping certain material
Yeah.
either in terms of its documents, title documents, or the physical possession. That is
Yeah.
what we call mortgage. But in case of simple mortgage, basically we are not giving anything but except an undertaking.
Yeah.
And that's good.
But see, it also depends upon the trust of the parties. If the see, normally mortgages are done between mortgages are done between the lender and the borrower. And in case there is so much trust, and if the bank is willing to lend, if the lender is willing to lend only on the undertaking, say Ratan Tata wants to borrow some money from a bank, and he goes and asks for that I want to borrow money. Do you think that the bank will ask him to deposit the title deed? Maybe credibility of the person itself might be big enough that just on signing of the paper they will lend him the money, right?
That we call guarantee. We generally give the corporate
No,
guarantee
no.
or personal.
Guarantee is a different kind of a contract. In the case of a guarantee, there is a creditor, there is a principal debtor, and there is another person who could be living person, I mean, or there could be body corporate who guarantees. And the guarantor says, in case XYZ do not pay his debt, I will be willing to pay. That there is no mortgage of a immovable property or even hypothecation or a pledge of a movable property. Or there may be sometimes you also have a mortgage, you also ask for a third party guarantees.
But in case of simple mortgage also,
Yeah.
you have also in the background that you have taken a loan or you have taken a debt,
Yes.
and
That's
then
why.
against that you are giving just a guarantee.
Yes,
Nothing
yes.
else.
No. Giving a guarantee means if you read the definition, it is says it is a creation of an interest in a specific immovable property. Giving a guarantee that in case I fail to repay this money as per these terms, this particular property X, Y, Z, say a flat number such and such, plot number such and such, street number such and such, will be available to the creditor. In the case of a indemnity and a guarantee, which is a part of the Indian Contract Act you might have studied, it is the surety individual who takes the responsibility for payment in case the principal debtor does not pay. I'm so happy you are asking very interesting question. Thank you very much.
It came to my mind. I was just going
That's,
through it and thought
sir,
that there
that's
was some
great. In case something comes to your mind and you do not clear your doubt, then this doubt will continue to hover you till you find another person to answer this. And today you have got an opportunity to answer, seek an answer here. And I am willing, in fact, all through I have been trying to encourage you to be as much participative as possible. In fact, in between, maybe you do not know, while changing over from the previous slide of Transfer of Property Act to this, for a few minutes, I was just watching at you. For a couple, 2-3 minutes when you were asking question, I was watching, I was able to see photographs of each one of you, video of each one of you.
Thank you so much.
Since we also have a constraint to cover a lot of syllabus in a given point of time, then that's why we are not able to have some layer chat. Otherwise, we could have spent another 2 hours in discussing some of these things. Right, friends?
Yes, sir. Thank you.
In case no further question is coming, can I go over to the next topic?
Yeah, sure.
Indian Stamp Act. You know Indian Stamp Act, some of you? At least
Yes,
company secretaries, chartered accountant, even engineers must be knowing at one point of the time or the other, you must have purchased a stamp paper, if not anything, for agreeing for entering into a bond or indemnity bond, or at times for entering into any kind of an agreement, you must have bought a stamp paper, or when you get any document notarized, that notary fellow that put a stamp and then paste a stamp, and over which he also put his rubber stamp and then signs it. What other places you use the stamp paper? You want to enter into a conveyance deed, say a sale deed, then you have to use the stamp paper. Yes.
Sometimes giving
Certain
power of attorney, some guarantee,
Yeah. You appoint an advocate to present you in a court of law, or you
Correct.
appoint somebody to act on your behalf, or enter into a transaction on your behalf, enter into a power of attorney, or you authorize some advocate to appear on your behalf in a court of law. You use the stamp paper at that time, yes. और कहाँ stamp use करते हैं?
Even for giving the affidavit, we use the non-judicial stamp paper.
Exactly, bond or an affidavit. What is the difference between indemnity bond and an affidavit?
Affidavit is sometimes you are giving the undertaking that okay, this in case if something happens, we are ready to do that time, or this has happened, we are within the authority of giving this type of undertaking or undertakes. That is
Actually, I'm sorry withholding you. You have mixed up both the things. Indemnity bond is you give a kind of an indemnity that in case your failure or in case of a failure on the part of another person, you agree to undertake to indemnify that indemnity holder, indemnified, sorry, indemnified of certain amount of loss that might take place to him because of your own act or because of the act of the third party. And in the case of a affidavit is a kind of an affirmation. Affirmation is a kind of a verification. When you submit certain statement of facts before the court of law, when you file a petition, court wants to make sure that you have not in your petition made any false statements. In case you make a false statement, the court asks from you to give an affidavit in writing. At the end of the petition, you always attach an affidavit, and where you say that I, son of such and such, resident of such and such, do hereby affirm that the facts given in this particular petition are true to the best of my knowledge and belief. So such kind of a commitment when you give, and nothing has been hidden there from, you know that, and all that petition has been prepared in my supervision, and I know these facts to be true and correct to the best of my knowledge. And once you give it, this is like a shapathnama, or a kind of a making a statement on oath or affirmation, right? Halafnama, yes. Okay, now you already know, but then you also use stamp paper when you have to post your letter. Say you want to send a letter from, say, Patna to Chennai, and you go to the post office, buy stamp, paste it on a letter, and the letter goes. Are the two kinds of stamps the same? No, they are different kind of stamps. The stamps which are used on issue of shares or issue of debentures, for entering into an agreement, on conveyance deed, on lease deed, on mortgage deed, these are stamps which are regulated under the Indian Stamp Act. The postal stamps are regulated under the postal law. Postal stamp is nothing but a consideration which the post office charges from you as a cost of carrying your letter from place A in city A to place B in city B. So they are two absolutely different, but since the methodology of affixing them and pasting are the same, sometimes the two kind of stamps are fixed. Then the stamps are also judicial stamps and non-judicial stamps. Whenever you file a petition in the court of law, sometimes you have to deposit certain amount as a cost of adjudication by the government authority, court fee jisko kehte hain. So those are called judicial stamps. But what is covered under the Indian Stamp Act is normally the use of the non-judicial stamp that we will be using. And when we study this Stamp Act, this will involve what are the documents on which stamps are required, what are the methods of affixing stamps on those documents, what are the documents on which there is no need for affixing of any stamp, and if the stamp has to be affixed or stamp, and the stamp is a kind of a duty, stamp duty it is called. It is a kind of a tax which goes to, I will tell you in a little while, goes to both central government and the state government. I will also tell you what kind of a tax goes to the central government, what kind of a tax goes to the state government. Both the cases, the Stamp Act is a on both state and central jurisdiction. So central government has a power to levy stamp duty on documents such as issue of shares, issue of debentures, memorandum of registration of the memorandum and article of association of a company, stamp duty is levied, it goes to the central government. Then all other documents where other than those where the stamp duty goes to the central government, goes to the state government. For example, registration of the sale deed, registration of the mortgage agreement, registration of the giving of a power of attorney. So in those cases, the money goes to the state government. Let us start studying the topic. You will find it relative, though it is the maximum used enactment, but it is a much less understood enactment. Very few of us, except of course at the time of passing of the examination, we study this act. Thereafter, we take it for granted, and whenever some stamp paper has to be used, we just ask the person concerned कि कितने का stamp paper लगेगा, कौन सा stamp paper लगेगा, and then we use that stamp paper. We really do not get much into the theory of the Indian Stamp Act. So today I am going to cover with you introduction of the Indian Stamp Act 1899, instruments on which stamp duty is levied, mode of payment of the stamp duty, valuation of the payment of the stamp duty. So on what basis, particularly in the case of a sale or a mortgage or in case of a lease, you pay stamp duty at vellum depending upon the value contained in the agreement. Person who are liable to pay stamp duty or person not liable to pay stamp duty, and in case there are defaults, what are the consequences? So Indian Stamp Act is a law relating to stamps that consolidates and amends the law relating to stamp duty. It is a fiscal legislation envisaging levy of stamp duty on certain instrument. Instrument is a document in writing. And whenever such document in writing is required to be registered, at that time or before, you have to pay stamp duty. So Act is divided into 8. Is the theory, like students like theory, you need not mug up all that, but just for your information. There is a schedule which contains the rate of the levy of the stamp duty. And this schedule is as long, total Act along with the schedule comprise of around 40 pages, where 25 pages is the rules and regulations relating to the stamp duty, and around 15 pages is long schedule which gives the list of the transactions or kind of a document on which the stamp duty is payable, and that also prescribe what amount of stamp duty shall be payable. So under section 226, stamp means any mark, seal, endorsement by any agency or a person duly authorized by the state government, and include adhesive or impressed stamp for the purpose of duty chargeable under this act. So whenever some duty has to be paid under this act, we take a stamp on which on one side of it you find this Ashok Chakra, Government of India, and that kind of a marking is there. On the back of it, some kind of a pasting mechanism is there. And particularly anybody who uses stamp, you will find he also keeps a small katori like thing, and in which he has put some sponge with a little water. He paste it like this. He just wetten on one side of the stamp, and adhesive stamp is pasted on the document over which the duty has to be paid. So sometimes they do not even keep that what is called that sponge paper and that container, and you just he puts it over his tongue, wetten it a little, and then paste it over a paper. Or it could be impressed stamp, where stamp amount is engraved on a sheet of paper, and then there is a stamping at the top. Then or denomination of the stamp paper is also written, that it is for 100 rupees, 200 rupees, wherever costly higher amount of stamp duty is payable. Normally we use those impressed kind of stamps, but I will also tell you some innovation which has taken place. Let me tell you here itself what happened. Normally whenever we want to buy or sell property, anything around 4 to 8% of the value of the property was required to be paid, or even now is required to be paid by way of a stamp duty. So to that extent, we have to buy stamp papers where the impression, security paper, and the watermark and all those things are given in the paper. So we go and buy it over those stamp paper, we write our agreement and then sign it by the seller and the buyer. What really happened was around year 2000 or little before that, there was a gentleman called Tehlgi from Maharashtra. That fellow knew the trick, and he himself purchased some old machine from a security printing press of Nasik. In condemned machines he purchased, himself privately started printing those stamp paper and started floating in the market. For quite a long time, 5-6 years, he remained undetected, and by that time we knew that he has already printed and sold fake stamp papers worth around, maybe, please correct me on the figure, maybe around 20,000 crores of rupees. And then he got caught and thereafter put behind bar and jailed, and during the jail term he died and all that. But one lesson was learned that anybody can, with a little trick, can hoodwink the government and put it to the huge losses. And as a result of which, there was some development where this impressed stamp, wherever high value impressed stamps are to be used, they are not used by impressed stamp by engraving it on a security paper. They are paid mostly by way of a e-stamp. Now the evolution of the e-stamp has come into being. So adhesive stamp is one in which either an adhesive on it when it is purchased, or which is intended to be affixed by adhesive, मतलब gum लगा के उसको use कर सकते हैं. Our impress stamp is one which is embossed upon a piece of paper and is attached and may be affixed by other means, including adhesive or you can also staple it. Or the definition of stamp has been inserted by the Finance Act 2004. And I was telling you that stamp duty on issue of bill of exchange, checks, promissory note, bill of lading, letter of credit, policies of insurance, transfer of share, debentures, proxies, power lies with the central government, and stamp duty in respect of documents other than those specified in the union list lies with the state government. Some of the state government friends, in the exercise of this power, has enacted their own state stamp act. And most of the state government have, while schedule attached with the stamp act is as old as 1899, but some of the state governments have from time to time revised this schedule 1. So there are two kinds of state governments. Some of them are having their own stamp act, and at number of places they have also brought in the amendment to the Indian Stamp Act. And some states have, in the exercise of this power, that is entry number 63, they have enacted their own stamp act. That's why, friend, you find lot of diversity and lot of differences on stamp duty payable on the registration of property in Maharashtra and that amount which is payable in Gujarat, or whatever is payable in Gujarat and Rajasthan, or Rajasthan and Meghalaya. So most of the states are having their own stamp law. But the central enactment relating to bill of exchange, then promissory note, bill of lading, etc., they remain uniform throughout. Okay, now what are the instruments which are chargeable to stamp duty? The following instruments are chargeable to stamp duty. Every instrument mentioned in Schedule 1 which not having been previously executed by any person. That means whenever you first time execute that instrument, whenever such instrument is executed on or after 1st day of July, that is the day when the Indian Stamp Act came into existence, it being effective from that date. And whenever you enter into any document which are mentioned in Schedule 1, and I told you Schedule 1 run into around 15 pages, like HSN code, or like when you study Customs Act, there is a long list of that schedule where different items are given, and on import or export of those items certain rates are mentioned. Like that in the case of excise or GST also, you have a long schedule which are mentioned. Like that in the schedule attached to the Stamp Act also gives the nature of the document and the amount of stamp duty payable on those document. So instrument, you already know, instrument includes every document by which any right or a liability is created in favor of another person, or purport to be. Purport to means it appears to have been undertaken or created or transferred, or it is limited or extended, extinguished or recorded. So sometimes you may enter into relinquishment deed in favor of other members of the family. You have a right in the family property, but you don't want to claim that right. Maybe sometime female members of the family, they don't want to claim their right in their parental property. They sign a relinquishment or extinguishment deed in favor of their brothers, or where already agreement is there, you want to extend that, or right, you want to transfer it, or you want to record some right. So that any document on which such recording take place is called an instrument. So I just wanted to give you some feel of the instrument. Instrument gives certain items such as administration bond, including bond given under section 256 of the Indian Succession Act. Granting a letter of administration means authorizing somebody to manage the family property on your behalf, or acknowledgement of any debt exceeding 20 rupees, or affidavit, adoption deed, agreement relating to the deposit of the title deed, and here the amount of stamp duty payable is mentioned. Like that, stamp duty is payable in Delhi, for example. Delhi, I was just wanting, since in the Stamp Act, I could not find the latest rate. I just browsed the website of the Delhi government and found that what kind of a stamp duty is payable. It says, the Delhi government website says, and it's the latest. I downloaded it only, I think yesterday. It says stamp duty is payable at the time of registration of the property if the property is acquired by way of a sale deed, conveyance deed, or a gift deed. And say, in case the transferee is a male member, then the value of the stamp duty shall be 6% of the consideration of the amount or circle rate of the property of that area, whichever is higher. And in case the transfer is done in favor of the female transferee, in such cases, 4% of the consideration or amount or the circle rate of the property. I will explain you a little bit. Either you should pay stamp, see, in case of a male and a female, rates are, yes.
Sir, please explain conveyance deed.
Conveyance deed is anything which conveys. You are right. Conveyance deed is you are a owner of the property, you have a ownership right, and this ownership right you transfer it in favor of the buyer. So that is called a conveyance deed. Conveyance means to carry, to give forward, to cede, to surrender in favor of somebody. Okay? Is it clear?
Okay.
You have a mobile on your hand. If you put the word conveyance in your Google Deed, you will find this kind of a terminology explained. You write conveyance means to cede, to carry, to convey any right in your property. Okay?
But sir, it doesn't transfer the title, no?
Yeah. That's why the transfer the title means convey the title from you to somebody else. So that's what the conveyance deed means. So I am telling you about the Delhi government website. It says whenever the property is to be transferred in favor of a male member, the stamp duty payable shall be 6% of the consideration or circle rate of the property applicable in that area, whichever is higher. What is this concept of circle rate? Concept of the circle rate is to avoid understatement of the consideration involved in the transfer of the property, and by virtue of which, in order to prevent the evasion of payment of the stamp duty, so they have put in that if you are registering a property located in this area, the minimum rate at which the stamp duty shall be payable, minimum amount or the value at which the stamp duty shall be payable is this. Say 3,000 rupees per square feet or 10,000 rupees square meter. So like that, they have explained about depending upon the plot area or upon the constructed area. So मेल मेंबर के फेवर में ट्रांसफर करेंगे तो 6% पेएबल होगा, एंड फीमेल के मेंबर में करेंगे तो 4%. यू विल से दैट व्हाई दिस inequality between male and the female. It is kind of a positive favor which have been done to the female member, realizing that most of the properties as on date are transferred in favor of, mostly in favor of the male members of the family. I think sizable percentage, even if you look at into your own household, you will find that most of the properties are registered in the favor of the male members of the family. And in order to bring about some equity for the last, I think, 15 years or so, this particular distinction has been made. Okay, and one thing more you will find, in case of Delhi, you want to get a registration, even on the gift deed, the same amount of the stamp duty is payable. But I'm told that some of the states like Haryana, if you want to enter into a gift deed, some token amount of 1,000 or 2,000 rupees worth of stamp duty is payable, not the whole amount of this. Okay, then for other deeds, as per the details given in Schedule 1 to the Stamp Act, I have given you some specimen, but you can have a look at it. I also clicked here, which is given in the PPT, but I found that same old schedule as was fixed in my Stamp Act, so that was there. I did not find any change in that. Maybe whenever you have to pay the stamp duty, you have to check up the latest schedule or an order or a notification available on that particular subject. Stamp duty on instruments executed outside India. If such an instrument is executed outside India, then still is stamp duty payable? Say there is a land located in, say, Calcutta, but you enter into an agreement in Bangladesh and get it executed. Is stamp duty payable to any instrument executed outside India relating to the property located in? Yes, it says every instrument mentioned in Schedule 1 which not having been previously executed by any person is executed outside India on or after that date, means I think 1st July 1999, which I told you a little while before. Yeah, 1st day of July 1899. So stamp duty is payable. And whenever instruments are executed outside India, if they relate to property situated in India, or if any matter or thing done or supposed to be done in India, or such an instrument is received in India, then the stamp duty is payable in India. Then illustrative list of the instruments chargeable to the stamp duty I have already shared with you: letter of credit, promissory note, bill of exchange, but not the check. On check, no stamp duty is payable, but promissory note, bill of exchange, stamp duty is payable. Bill of lading, you know, whenever you ship the goods from one place to another, say from India to somebody in UK, so when you deposit the goods with a shipping company, the captain of the ship issues you an agreement or a type which is called a bill of lading, on which stamp duty is payable. Like that bond, regarding bond, we have done a lot of talking. Conveyance deed, we have done a good amount of talking. So on that also stamp duty is payable. Like the deed, marketable securities, mortgage deed, insurance policy, lease contract, or any other type of contracts which are mentioned in Schedule 1. In nutshell, the Act requires payment of duty on any document by which any right or obligations are created, transferred, extended, extinguished, or recorded. And stamp duty is also payable on all documents mentioned above. This is only indicative list, along with other type of instrument documents such as memorandum and article of association of a company, which require payment of stamp duty, issue of share, debentures, etc. Okay, now there are certain rules relating to a fixing of the stamp duty. How much stamp duty shall be payable? It says several instruments used in a single transaction of sale, mortgage, or settlement. Say, for example, there is a single, there are several instruments are used, but transaction is one. Say, it could be, I am transferring you my property on credit basis. So there is an instrument we have signed. But at the same time, you are not paying the entire amount to me in one go. You say that this amount shall be payable by way of an annuity over this much period of time. So we sign two agreements. One, I transferring you my immovable property, and then you signing a different. We could have signed in the single document, that how the consideration will be paid. So that could be signed in a single instrument. But if for any reason relating to the same transaction, if we sign more than one instrument, then in such cases it says where in case of any sale, mortgage, settlement, several instruments are employed for completing a transaction, the principal instrument only shall be chargeable with the stamp duty prescribed in Schedule 1, and for any conveyance, mortgage, settlement, and each other instrument shall be chargeable with stamp duty of only 1 rupee. So if they are signing, and so I given a, if we are signing any illustrate any supplementary kind of an instrument, on those no separate stamp duty is payable, except that you can put a token, you have to put a token stamp duty of 1 rupee. It's I just give an illustration. Brother A executed a gift deed in favor of brother B. So whenever gift deed is done, he has to pay stamp duty. By another deed, B, the donee, make a provision for the living expenses of brother A and hypothecating a part of the same very asset in favor of brother A in order to secure the payment of the living expenses. So the one agreement is that gift deed from A to B, another deed is from B to A, promising to take care of him during the old age. In such cases, even if the two instruments are signed, so only on main instrument the stamp duty will be payable. On the supplementary instrument, you have to pay only stamp duty worth 1 rupee, not more. So it was held that two documents were part of the same transaction. They amounted to a settlement, and Section 4 applied, which means you have to pay stamp duty only on one document. Another is just reverse of it. In case there is a single instrument.
Sir, there is a small question.
Yes, please.
Yeah, in this case, when two documents are considered to be a part of one transaction, the
Yes.
stamp duty to be paid is combined amount of both the document or only
No,
the first?
no, only on one main document. Since in this
The
case,
main.
I gave an example, A brother executed a gift deed in favor of B, and as a part of that, B said, okay, gentlemen, you have gifted me so much of property, I will take care of your old age, and hereby I am signing this instrument. So only A is the main document, the B is only a just supplementation to that. When I give you the next section 5, you will be able to better understand it. Sometimes it may happen single instrument relating to several distinct matter. By the same instrument, I transfer you my house number A. Same instrument, I also promise to give you my car number B. In the same instrument, I also transfer to you something else and promise to give you. In such cases, what stamp duty will be payable? Any instrument comprising or relating to several distinct matters shall be chargeable with aggregate amount of the stamp duty with which the separate instruments, each comprising or relating to one such matter, would be chargeable. So if in the same instrument I am transferring you so many rights relating to different properties, in such cases, the stamp duty payable on transfer of right A, transfer of right B, transfer of right C, they will be added up, and the lump sum amount of stamp duty shall be payable. Like that, instruments coming within several descriptions of the schedule, you know, there was a lot of dispute as to, under the GST law, whether the paratha should be taxable at the same rate as roti or something different. What should be the rate of duty payable on, say, sanitizers? There is a lot of dispute whether it falls into the category of, say, healthcare, what is called as soaps and detergents, or it falls under the category of a medicine. If it were to be under the category of a medicine, it will be payable at 5%. If it is under the category of a hygiene item, in such cases it will be, say, 12%. Like that, there were dispute, and just as there were dispute relating to under the GST, like that, when you look at the long schedule attached with the Stamp Act, there could be issues as to what amount of stamp duty shall be payable. It says that where duties chargeable are different, be chargeable only with the highest of such duties, subject to the provisions of Section 5, an instrument so framed as come into within 2 or more descriptions of Schedule 1, then whatever description have the highest amount of stamp duty, that amount shall be payable. Like that, who are the persons liable to pay stamp duty? So it is the discretion of the parties that they have to decide as to who will be paying the stamp duty. Normally, in the case of a sale deed, the buyer become liable to pay the stamp duty, but the two parties can. In the case of a lease, also leasee should be normally pays the stamp duty, but the party sometimes agrees that the stamp duty shall be borne equally or in this proportion. So it is up to the parties in a contract to decide as to who will bear the stamp duty. And where no specific arrangement between the parties is there, Act stipulates the following parties to be responsible for making payment of the stamp duty. So,
Sir,
yes,
so like you gave example of transferring a house, car, and all
yeah,
other stuff in the same agreement, then
yeah,
the total amount is aggregated. So it's compulsory to be in the same agreement.
not necessary. You can enter into different agreements also, but in
Then
case
also
of
it is aggregated.
yeah, then also on individual, say somebody is transferring you a house, usko on that different stamp duty will be payable. Later on, you are transferring say some movable property by virtue of an agreement, different amount of stamp duty shall be payable. Then along with it, he also wants to relinquish his right of share in the HUF, on which different amount of stamp duty will be. You can enter into different agreement, but in case you decide to enter into a single agreement, so lump sum amount involved in all the transaction will be the amount for which the stamp paper should be purchased. Okay, is it clear?
Yes, sir. It's clear.
Okay. Now, persons liable to pay stamp duty in case of instruments like bill of exchange, customs bond, indemnity bond. Then person who draws or makes or executes such instrument is liable to pay stamp duty. In case of an insurance policy other than fire insurance, person effecting the insurance, that is the insured person, has to pay stamp duty. In case of a fire insurance, the person issuing the policy, that is insurance company or the agent, has to pay stamp duty. And in case of instruments of exchange, stamp duty has to be paid by both the parties equally. Then instruments not chargeable to stamp duty, any instrument executed by or on behalf of government. That means whether central government or state government, in cases where government would have been liable to pay stamp duty in respect to those instruments, stamp duty is not payable. Normally, as I said, that in case of parties can decide themselves, but where there is no decision, say in case of a conveyance deed, normally the transferee pays the stamp duty. In case I buy land from the government, so as a transferee, I have to pay the stamp duty. But if I sell land through the government, that means my land is acquired by the government, government should be liable to pay the stamp duty. And wherever the central government or state government is liable to pay stamp duty, no duty shall be chargeable in that. Any instrument for sale, transfer, or other disposition of any ship or a vessel, etc., registered under the Merchant Shipping Act, no stamp duty is payable. Like that, any instrument for carrying out the transaction in SCZ or with the SCZ developer, no stamp duty is payable. And what are the consequences if the stamp duty is not properly paid? Unstamped instruments are there, they are not enforceable. If an instrument is not duly stamped as per the requirement of the Act, such instrument does not have a legal enforceability. That is, the party cannot use such instrument as a valid evidence to enforce their right in a court of law. However, in case there is a technical default in fixing of a stamp duty, say for example, stamp duty is somewhat short paid or it has not been properly crossed, so those technical defaults can be corrected before the suit is filed in the court of law. Then mode of payment of stamp duty, I have already told you something, adhesive stamp, then stamp through impressed means where impression is created on a security paper, or it could be through a franking machine. It's known what is a franking machine? It is a kind of a metering kind of an equipment in which certain amount of value can be got filled in advance, and whenever you use, say you can say you want a 5 rupees stamp, put the meter on a 5 rupees, fold it, put a document where you want to put a stamp duty, just circle it, and the stamp of that amount will get printed on that instrument, and to that extent, accumulated amount deposited by you with the revenue authority, they will get reduced. That's the function of a franking machine. And in rare cases, collector can also allow you the payment of stamp duty in cash, but not always. Then impress stamp means where some engraving or embossing is done on a stamp paper, or e-stamp are also available through the authorized stamp vendors. Mode of payment of franking machine I have already covered. When is stamp duty payable? For instruments executed in India, the instrument need to be stamped before or at the time of execution of such instrument. Before or at the time of execution. For instruments which are executed outside India but chargeable to stamp duty in India, I said relating to the property located in India, relating to some action to be done or implemented in India when the instruments are brought in India, within 3 months of their bringing those instruments to India, stamp duty must be fixed or paid. Then valuation for the purpose of stamp duty. So on the value, wherever ad valorem duty is involved, so on the value of that stamp duty, just I gave an example of 6% of 6% or 4% of the value involved in a transaction, stamp duty is payable on the value of such stock or in case stamp duty is payable on issue of stock or share on the market value or fair market value of those stock or share, the ad valorem stamp duty shall be payable. And where an instrument is chargeable with ad valorem duty in respect of the money expressed in currency other than that of India, say instrument is executed in US dollars or in francs or in some other currency, say pounds or euros, in such cases, stamp duty shall be calculated on the value of such money at the rate or currency in India. So on that value, it will be payable. Interest not to be, whenever the amount payable under the instrument, it also involves the obligation of the payment of certain interest. Only the face value of the transaction is taken into account for the purpose of payment of stamp duty. Interest part is not taken into account. Where any property is transferred to any person in a consideration wholly or in part of a debt due to him, say I owe you 20,000 rupees, and in return of it, I also transfer to you my property worth 50,000 rupees. So you will be paying me only 30,000 rupees after adjusting or appropriating 20,000 already owed to me. But on what amount the stamp duty shall be payable? Stamp duty shall be payable on the gross amount. And valuation of an annuity in case the amount is payable at an annual recurring amount. In such cases, the total amount payable over the annuity period shall be taken into account, and on that stamp duty shall be payable. And where the annuity is payable in perpetuity, say I give you something, in return of it you agree to pay certain amount in perpetuity for all times to come, then whatever amount is payable over a period of 20 years, so that will be taken into account for the purpose of calculation of the stamp duty. And where the sum is payable in indefinite time, but such time is terminable with the life of a person on the date of such instrument, in such cases, the amount calculable, if it is perpetuity 20 years, if it is linked with the life of the person, in such cases, for 12 years, whatever amount shall be payable, that will be treated as a value for the purpose of calculation of the stamp duty. And wherever the value is cannot be determined or ascertained, in such cases, what value you will take into account? In such cases, the parties are free to decide their own value, but in case whatever value they decide, and in case the time for seeking remedy under that instrument comes, they shall not be entitled to recover under such document any amount in excess of the amount for which the amount duty, stamp duty has been paid. For example, for what amount should I insure my life? So if I ask my mother, my life is worth crores and crores of rupees. I go to the insurance company and ask the insurance company, so I want to insure my life for 100 crore. वो sage and the insurance company will be very happy that you are a very costly person. But in case you want to value yourself for 100 crore or 10 crore, you have to pay this much of a premium. So here also you can determine, in case the value is not determinable at the time of entering into an instrument, you may decide whatever value you want. But in case whenever you want to seek a remedy, the remedy will be available only to that extent for which you have paid the stamp duty. Then so whatever stamp duty you pay, whatever kind of an instrument you enter into, you have to write on it value of the property, value on which the stamp duty has been paid, and the amount of stamp duty payable. So I don't know whether any of you have an experience of entering into a sale deed. They ask you amount of the consideration, circle rate of that area, amount of the stamp duty paid. So whichever is higher, circle rate or the actual transaction price, whichever is higher. So all the three will be written on the stamp paper. Valuation and payment of the stamp duty for property. In case the property is sold in part, say you enter into an agreement for purchase of 6 flats to be delivered to you over a period of 6 years, 1 flat every year. So you can pay a portion or a pro rata amount of stamp duty. You can enter into a single agreement, but the actual payment of the stamp duty may be done as and when a particular flat is transferred to you. Instrument की definition मैंने आपको बता दी. And then amendment brought about to the Finance Act 2014. The amendment have introduced a single point of collection of stamp duty by authorized entity by issue of transfer of securities. Particularly, this amendment has become necessary by coming into force of the what is called as depositories. Normally, instrument stamp duty is payable on the instrument, but anybody who was transferring shares through the depository, they were not paying the stamp duty, so they have been brought within the purview of the payment of the stamp duty. So whenever a company issues shares or a debenture or any kind of a security, at the time of an issue, they have to pay stamp duty. Then stamp duty on issue of securities that has to be paid by issuer other than through the stock exchange or a depository. So stamp duty is now collectible either by the stock exchange or by the depository, normally by the depository. Then stamp duty on issue of, in case the issue of security is made by the issuer, otherwise than through the stock exchange or the depository, in such cases, the issuer has to pay stamp duty. That means in case there could be any situation where physical security in the physical mode is issued, the issuer will have to pay stamp duty. In case of the instrument or a transaction in stock exchange or depository, I think I got repeated. In this part, a new section 9A has been included, which provides for a stamp duty on sale of any security or repeat हो गया. Basis of payment of the stamp duty shall be market value or the fair market value. And whenever centralized payment of the stamp duty is done by the issuer, in such cases, he will be paying the stamp duty to the state government within 3 weeks of the month, 3 weeks of the close of the month in which the securities have been issued. Basis of collection of the stamp duty within 3 repeat. E-stamping का मैं आपको बता रहा था कि e-stamping is a computer in order to prevent Tehlgi-like scandal which took place long time ago. So e-stamping is a computer-based application and is secured by way of paying non-judicial stamp paper to the government, and the prevailing system of the physical stamp paper franking machine is being replaced by e-stamping. The benefit of the e-stamping are e-stamp certificate can be generated within minutes, very quick. E-stamp certificate generated is a tamper-proof. Then e-stamp certificate generated has a unique identification number. They also give a running number through which you can verify for what amount the stamp duty has been paid. Easy accessibility, faster processing, security, cost saving. So that kind of a fraud can be avoided. So with this, I complete. But before I part, I will definitely like to have a brief interaction with you. You want me to keep this file open or close it? Okay, I've closed it. So please, we can, in case you have any doubt, feel free to ask me. I know, I'm sorry, I was a little faster in the second presentation, but as it's a difficult topic bhi nahi tha, it is relatively easier as compared to the Transfer of Property Act. You have any clarification? Anybody?
Sir, will you share this slide with us? Presentation.
This PPT you will be getting right today.
Okay.
I will mail it to Mr. Sandeep, who is an organizer for this, and you will get it. If you permit,